The second part of this lesson will lead you to the principles on real property taxation as pronounced by the Supreme Court in the cases it has decided. I am discussing 3 cases decided by the Supreme Court recently. The first case is the Metropolitan Waterworks and Sewerage System versus Local Government Unit of Quezon City, docketed as GR number 194388, decided on November 7, 2018. The question raised is whether the real properties of Metropolitan Waterworks and Sewerage System located in Quezon City are exempt from real property tax by the local government unit. The Supreme Court pronounced that yes, the real properties owned by the Metropolitan Waterworks and Sewerage System are exempt, except those portions that are alleged and proven to have been leased to private parties. The Supreme Court emphasized that the government instrumentality exercising corporate powers is not liable for the payment of real property taxes on its properties unless it is alleged and proven that the beneficial use of its properties been extended to a taxable person. The second case is the Manila Electric Company versus the City Assessor and Treasurer of Lucena City, docketed as GR number 166102, decided on August 5, 2015. 2 relevant issues were raised in the said case. First, whether Meralco is exempt from real property tax, and second, whether the transformers, electric posts, transmission lines, insulators, and electric meters of Meralco are considered machinery and is exempt from real property tax. As to the first issue raised, the Supreme Court raised that when the franchise of Meralco was expiring, the Local Government Code of 1991 took effect in January 1, 1992. Thus, the franchise could no longer be given credence as to the exemption. Moreover, Section 234, Paragraph 2 of the Local Government Code of 1991 clearly withdrawn upon its effectivity the exemptions from payment of real property taxes granted to natural or juridical persons, including government-owned or controlled corporation. To reiterate, Section 234, Paragraph 2 of the Local Government Code of 1991 provides that 2. Other exemptions withdrawn, all other exemptions previously granted to natural or juridical persons, including government-owned or controlled corporations, are withdrawn upon the effectivity of the Code. Given this, Meralco is no longer exempt from real property taxation. It was noted also that the subsequent franchises for operation granted to Meralco are silent on the matter of exemption from real property tax or any of its properties. The Supreme Court further stated that tax exemptions must be clear and unequivocal. A taxpayer claiming a tax exemption must point to a specific provision of law conferring on the taxpayer in clear and plain terms exemption from a common burden. Any doubt whether a tax exemption exists is resolved against the taxpayer. The second issue in this case is whether the transformers, electric posts, transmission lines, insulators, and electric meters of Meralco are considered machinery and thus exempt from real property tax. The Supreme Court resolved by saying that it may qualify as machinery under the Local Government Code and is subject to real property tax. The Supreme Court even showed the changing and expanding definition of machinery. It highlighted that under Section 199(o) of the Local Government Code, machinery to be deemed a real property subject to real property tax need no longer be annexed to the land or building, as these may or may not be attached permanently or temporarily to the real property, and in fact, such machinery may even be mobile. The previous ruling of the Supreme Court in 1965 Meralco case no longer hold true under the Local Government Code of 1991. It was emphasized that while the local government code still does not provide for a specific definition of real property, Section 199(o) and 232 of the said code respectively gives an extensive definition of what constitutes machinery and unequivocally subjects such machinery to real property tax. Also, the machinery subject to real property tax under the local government code may or may not be attached permanently or temporarily to the real property. To also resolve the related question, which should prevail, the new civil code or the local government code, the latter should prevail. The former is a general law governing property and property relations, while the latter is a special law granting local government units the power to impose real property tax. As to the last case that we are tackling, it is entitled Capital Wireless Incorporated versus Provincial Treasurer of Batangas. It is docketed as GR number 180110 and decided on May 30, 2016. The issue in this case is whether submarine or undersea communication cables are exempt from real property tax. The Supreme Court resolved that it is not exempt as it is akin to electric transmission lines, which the court has recently decided in the Meralco case, the one I was just referring to a while ago. The Supreme Court further stated that both electric lines and communication cables in the strictest sense are not directly adhered to the soil but pass through posts, relays, or landing stations, but both may be classified under Article 415, Number 8 of the new Civil Code as real property. We hope that even with these few cases and short time, you were able to grasp the basic principles of real property taxation. Thank you for your undivided attention. Our next lesson is something that everyone could be interested in. It is about last will and testament. Again, thank you, and see you in the next lesson.